Medicine,
Law, friendship. This is Dr. Long and Lawyer Nik. You're listening to the Medico-Legal Brief.
one doctor, one lawyer, and a whole lot of gray area. Hey Nick, how you doing?
I'm doing well today, Long. How are you doing today?
Good, good. I'm excited. I'm ready to get out of these scrubs and into some pickleball action here soon.
Yeah, I think one thing that the people don't know is that you're sponsored in pickleball.
Yeah, not that good. It's a local, well, not really local, but a Wisconsin-based company, and I was able to get a little small sponsorship with them. So it's nice to be able to play under a name and kind of promote the brand. But really, it's just getting out on the court and getting some exercise is the goal. And we still have yet to play pickleball together.
I know I had a few surgeries this past year, and whenever you're visiting, we're usually out eating instead of trying to get a workout in. So with pickleball, are there a lot of individuals that get sponsored, or is it kind of like the more passion you have for the game, the more likely it is to have that kind of connection?
Yeah, it's usually more passion, more dedicated. Like you're spending a lot of amount of time on the court playing tournaments. Because the idea behind the brand is that you want to show it to the masses, right?
Yeah.
So the more that you're playing, the more you're exposing other people to the brand. I'm personally not one of the people that is pushing people to buy paddles, but if people come up to me and say, "Hey, what paddle you're playing with?" Obviously, I'm gonna show them, "Hey, this is the paddle. If you want a link, a discount, have at it." But yeah, ProLite. I play for ProLite, so I'm gonna do a little plug here. Might as well. Wisconsin based.
So I know that today we have a pretty interesting topic that we want to broach.
Yeah, so today's topic, I think we'll intertwine the medical legal aspects of our podcast that we're trying to bring forth. And it's going to be about the malpractice in general and what that means for a physician and what that means for a lawyer that is on the case of a malpractice issue, right?
Yeah, and to full disclosure for everybody listening, I am not a medical malpractice attorney. I've never done a medical malpractice case. I didn't even take medical malpractice in law school. So I have zero training on it. But I think what we're going to try to do here is from a lawyer aspect is ask Dr. Long questions and kind of understand from the physician point of view how they learn and how they are trained to avoid malpractice and what those standards of care are and what those duties of a physician actually are. So I think it's going to be a really interesting conversation.
Yeah, and similarly, I am by no means an expert. I have luckily, knock on wood, have not had any sort of malpractice case against me. And I'm hoping to avoid that for a very, very large part of my career. I think I can speak to the stresses behind what malpractice suits may mean to us and how it may affect our livelihood, the way we practice, how it affects medicine in general. So that's kind of the nitty-gritty stuff that we're going to get into, not necessarily what happens when you do get sued or when you do going through a malpractice suit.
I just want to start. A lot of things are based in education, right? We got to where we are now from our schooling. So when you were in school, did you have any formal training on what medical malpractice is, how to avoid being sued for medical malpractice? And I think that can even go as far as maybe not a formal medical malpractice lawsuit, but how do you avoid disciplinary action from maybe your board or your hospital or the hospital community, so on and so forth?
Yeah, you're going to be surprised to hear this, but we actually have no training ever through medical school, through residency. We are never actually sat down and discuss what malpractice means, what malpractice suit looks like. These are all things we learn on the job or learn through colleagues or attendings or mentors as we go through our career. It's not anything that we formally sit down for, like, one semester or two-week class or anything like that at all, which I didn't even think about or consider is quite an important part of a physician's career to know these things. But it's really not something that is taught a part of the curriculum.
I feel like the medical creed is do no harm, right? So if the marching orders to physicians and anybody in the medical field is do no harm, I feel like there is a lot of gray area in which you have to make a decision. That decision can be good or bad. It could result in something that helps the patient. It could also result in something that hurts the patient. So there's a very thin line of, okay, am I doing something that actually does harm or not?
As we go through education, obviously we take an oath, the Hippocratic Oath, which tells us to do no harm to any patient at any time, right? So the goal is to never harm a patient. From the get-go, before we even start medical school, we take that oath. And then as you go through medical school and residency, there are always boundaries that are set there, and we are always reminded of those boundaries, I guess is the easiest way to describe it. As you go through, these are probably the line that we don't ever want to cross. We're never told what happens if you do cross it, but we are told that bad things will happen. We just don't know how bad. And so I think that as we go through our training, I guess inherently we are taught those things, but officially we don't, which is kind of a disservice. I guess that would be something to tweeze out. I don't know if that is beneficial to keep it so non-biased, right? I imagine if I were to have been taught all the legalities behind malpractice, what would cause it, I guess I would be practicing medicine in a different light. What we term a lot in medicine is cover your ass, CYA medicine, and that's basically any decision you make, you always want to cover your ass, you always want to document, you always want to make sure that there is something to fall back on, that if something were to go wrong, there is a reason behind it. We are always taught that you document every little detail. So if you didn't document it, it didn't happen. That's always a statement that's always instilled in us. So if I said that I told the patient, hey, you need to go home, take Tylenol, ibuprofen, but I didn't officially write that in the note, then the person reviewing that note later on, whether that's a lawyer, whether that's someone else in administration, will say that I never spoke about those things. And it's true, because there's no other way anyone that wasn't in the room can stand to it. So,
Yeah, that's very interesting, the lack of formal training and then into the hesitancy, because I think that not necessarily that lawyers get too bad of a rap, but from a business owner, I've talked to a lot of business owners. I know I'm kind of shifting gears here, but business owners are hesitant to deal with lawyers because it is the lawyer's job to identify the risk and the liability. So if a business owner wants to go, 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 at that point, the lawyer says, hold on, wait, come on back. Then there's a problem there because you're limiting the creativity, you're limiting the dynamics. And so I can see where a doctor may be a little bit more hesitant to do certain things, knowing that there could be legal repercussions on the other side.
yeah. And I feel like now that we're kind of again discussing it in more details, I'm kind of thinking back into the way I practiced. Like I wouldn't go out there and prescribe a brand new medication that I've never prescribed before, or I would never go out and prescribe a medication that a rheumatologist or a specialist would prescribe, because one, I don't know all the information, all the data behind it, even though I could look it up. There are websites out there, apps out there that physicians use specifically for those things, is to look up the side effects, the mechanism of action, when to use it, how to use it, dosing. So I could look it up and prescribe it myself. Legally, I can prescribe it. But if something were to go wrong, you then have to figure out, was I in the right place to prescribe it to this patient when it's not a medication that I normally would prescribe. It doesn't fall within my scope of practice, right? But the other interesting thing is that scope of practice is very different for a family physician versus a surgeon versus an OB-GYN. Like family physicians, we have to know a little bit of everything, but that doesn't mean I have the full gamut of prescribing whatever I want. It's still very narrow within what we are taught in residency and medical school.
And maybe that's a good segue into how do you as a physician define medical malpractice? Like you hear that term, what comes to mind as far as the definition?
Yeah, I see the most malpractice suits when some sort of patient harm has occurred, whether that is a surgical case gone wrong, whether that is a major side effect to a medication that has caused a life-altering event. That's usually when you hear about a malpractice case. Doesn't necessarily mean the case is won by the patient or it has favored the patient. It just means that it has been brought up as something to look into. And so as a physician, the malpractice cases, it's something we want to avoid altogether because it's just stressful to deal with. And I know that malpractice cases can go on for months and sometimes even years before they even settle. So that is something that you live with every single day as you continue to work and see new patients, which only continues to alter how you practice even more. So if I'm already hesitant to prescribe opiates, so that's something that well within any physician's arsenal to prescribe if they wanted to. But if I prescribed a certain set for one patient, chronic pain. Let's say they came in chronic back pain and I gave them some opiates and something just crazy happened. They went into psychosis, had hallucinations, and ran out into the street and then ended up losing a leg. Crazy case, but they ended up suing because I prescribed them opiates, which is what caused the psychosis. Then obviously moving forward, any patient that I'm going to prescribe opiates for, I'm going to be even more hesitant for it.
No.
Even if there's an indication, right? If a patient came in for cancer, I'm still going to second guess myself and say, hey, should I be prescribing this person opiates? What if it happens again? So I think as these malpractice suits, they're great for patients when it's valid, but sometimes it's out of the physician's control. Not all malpractice cases are due to the physician's intention to harm. I think majority of physicians are not going out there intentionally trying to harm patients.
I think that leads to the legal definition. Generally in the law, malpractice occurs when a standard of a professional is violated, whether intentionally or negligently. In the law, negligence is what we call a tort. It's a huge part of the civil world, and it can also be part of the criminal world as well. And for those who don't know, civil is the ability for one party to sue another party. So that could be person to person, business to business, business to person, entity to entity. Criminal is when the state sues the individual. So there might be a criminal issue in which, you stole something, or you were driving under the influence, or you harmed somebody. And at that point, a criminal case may come your way in which the state is suing you in that context. But with malpractice, there's that standard of care. There's another notion in law, which is the reasonable person. This reasonable person is this fiction of what would a reasonable person do in this situation. And if somebody can show that a reasonable person would not do something or would do something, it helps bolster your case or your argument. So under a malpractice, I would assume that the standard of a reasonable physician is the baseline for, did you do something that was negligent or intentional that caused harm to a patient?
Yeah, and exactly what you just said. You just said it in a much more lawyerly way than I
Yes.
did. But that's basically that example I gave where you give the opiates and a psychosis happens. That is so out of the norm that I think in that particular malpractice case, if the physician was being sued by the patient, they would bring out expert witnesses who know this topic well, and they will discuss, well, did the physician prescribe the right dosing? Was it more than the standard? Was it less than the standard? Is this an outcome that was expected or unexpected? Was it within, control of the physician, or was this just out of the blue on, this particular case of psychosis? That is not a common side effect. And so I think in that particular example I gave, the malpractice suit would be settled or lost by the patient. I don't think that the physician would actually be found liable for that particular issue. But there are so many cases out there where patients, they've been harmed and all they want is some sort of compensation. So they may sue for the smallest thing. And what actually happens in malpractice suits is they usually try to sue everyone involved. So any name that is in the chart, the nurse, the medical assistant, the hospital, and the physician, everyone gets named. But as you go through more discussions and settlements, and I know there's a legal term for it, but where you gather more evidence, then they start dropping people. Because then the lawyer decides, okay, who is the one that will most likely lose if we continue to pursue this?
That's a very on the nose comment. So the legal term that you're looking for is discovery. So discovery is the process of going through and gathering all the evidence. And in the legal world, you are allowed to ask the opposing party for evidence, whether it's transcripts, whether it's charts, whether it's images, whether it's, recorded conversation. You can ask for that evidence. And like we always say, if there is a disagreement as to turning over that evidence, you either reach an agreement or you go ask a judge. And then there are many times where lawyers have to go to the courtroom and say, Judge, I need this evidence from the opposing counsel. And the opposing counsel says, I'm not giving you that. I have no reason. And they have that argument right there at the bench. But to bring it back, we are actually taught that you sue in any case, everybody and anybody who could have touched the case. And the reason being is all the defendants that are named will end up either having to go through the discovery process in which the lawyer says, actually, you know what, this is a waste of time. There's maybe some liability in keeping this entity or this individual on the case because, you know, we might open ourselves up to attorney's fees. There's just instances in which you might drop defendants. But for the most part, what we're taught is you sue everybody and you let the defendants fight it out, because now the defendants have to come and say, hey, look, it wasn't us, and here's why. Let me prove to the court why I wasn't involved, or I wasn't negligent, or I had nothing to do with it. And that's part of the lawyer business aspect is you sue everybody, and you definitely sue those with the deepest pockets. Because if you're suing the individuals that don't have any money, then what are you doing for your client? You can't give your client their arm back. You can't give your client their sight back, or you can't fix the scars. So monetary compensation is the way of the world. And for most part, with medical malpractice, the lawyers will take the case on contingency, meaning that they won't get any money unless they win. So it is in their best interest to sue everybody, sue as much money as possible, and then try to, you know, settle up at the end, whether it's with a formal settlement or if it's actually going through a full-blown, you know, trial.
And I think that's a good lead into, as you said, who has the bigger pockets. It's usually the employer first, right? Obviously, the health system has the biggest pockets. That's who's going to be able to pay out the most. And then the physician is usually the next in line. And so if a case were to come forth, it's usually those two at the end of the day that has to deal and settle and manage what's going on. With that said, I think going into the details of what a physician has to do on a day-to-day basis to try to avoid medical malpractice is, one, have a malpractice insurance. Right? You have to have that to work. Most employers will not allow you to work without it. But basically, malpractice insurance, for example, if you're covered entirely, including if you were to leave the health system, you are still covered by that malpractice, even if a case were to come up 4 or 5 years down the line. So there's a lot of nuances between the different types of malpractice insurances, but that's definitely something that you want to make sure you have. And most employers will cover that for you. There's not really anything else that the individual physician needs to take care of or buy in addition to. So it's not like something that you have to do like umbrella insurance.
For medical malpractice insurance, is there like a policy amount of coverage? Like what is
Yeah,
it
there
covered?
is always a minimum policy amount. It's in the millions for sure.
Yeah.
For the minimum.
Well, that's very interesting that you mentioned insurance, because I think that's also something that plays a role in any medical malpractice case. If you see anything that doesn't jive with what you see, please, you know, correct me. But from my understanding, somebody comes in, they need surgery, that let's just say they need a routine procedure done, and some sort of negligence occurs that results in bodily harm or injury. Well, usually insurance is paying that cost up front, and they're paying for the subsequent treatments. So if something occurs, insurance is still going through and covering. So when a medical malpractice case occurs, the insurance company is standing off to the side saying, hey, we paid the money, we need to be made whole as well, because we've covered the bill. There was negligence that occurred, so we need to get paid first off of what we've put out there for the patient. And that adds, I think, a whole different dynamic. And again, not a medical malpractice attorney, I don't know the ins and outs of it, but I would assume that the attorneys for the insurance company would then get involved in a medical malpractice case because they're also wanting their piece of the pie. And I think that's another dynamic that some people don't realize is they think, okay, I'm going to go and I'm going to sue the hospital, I'm going to sue the doctor, I'm going to get paid. But it's like, well, you didn't actually make any payments to start. Your insurance company made those payments. So technically, the insurance company is going to get their payment back if you win.
There's just so many nuances for medical malpractice. It differs from state to state as well.
Yeah.
There are caps in certain states. I know that when we come out of residency and we're choosing where we're going to settle down, that's one of the biggest deciders is, are you going to go to a state that is physician friendly, where suits are less common, or there is a cap, no matter what the case is? It's a big burden. And again, I didn't even think about it until we had this conversation today, that we aren't truly taught much about it. And it's just something that one deals with when it crosses your table. and hopefully it doesn't. But I think there's a statistic out there that each physician will be sued or be part of a suit case at least once every 15 or 20 years. They will be in part of some case, whether they're dropped or not.
For those of you who aren't aware what Dr. Long's saying, a cap is essentially when you're like in Texas, for example, there is a non-economic cap of $250,000. So if I am suing the hospital and I am wanting damages that are non-economic for emotional distress, for example, I can only get capped at $250,000. Now, economic is your actual monetary damage. So that could be lost wages, that could be lost wages in the future, that could be the actual money spent on rehab and therapy and the surgeries that fix you. So that's what he means when we lead to these caps, is that each state is different. Each state can set those caps. And sometimes that means that if you're in a physician-friendly state, that helps with the liability on the back end. But if you're in a state that kind of looks at the opposite, that liability increases drastically.
And I haven't looked onto the international stage, but I definitely would not be surprised that the U.S. probably has a higher percentage of cases brought to physicians than other countries. One, because they don't have the same sort of system foundation, and then also two, because we are very much a sue happy country, right? Everything that you do, if it goes wrong, you could potentially go out and sue for it. We hear all the cases about hot coffee being poured on someone and getting a burn, and then they sue McDonald's, I think it was, or Wendy's, and win. Like crazy, crazy scenarios like that. So it's even more concerning when you're dealing with patient lives, medication, surgery, things that are just out of your hands sometimes. And so it's a very stressful job, and definitely something that everyone should consider. Can you manage or handle that stress or anxiety once you're in the thick of it? Obviously, we all try to avoid it, but sometimes it's unavoidable.
Yeah, that's actually philosophically, as a lawyer, that's something I have a problem with, is the fact that you can sue anybody for anything at any time. I like that everybody has access to file a lawsuit. I think that's very important. But if you go down the route and you're just sitting in your home and all of a sudden you get served with papers saying that you are now a defendant in a case or a respondent in a case, it's very frustrating because even if there's no merit and the court finds that there's no merit and the court dismisses it, you still have to show up and respond. So in that moment, you either have to respond yourself or you have to go find an attorney, pay that attorney, and have that attorney show up to court and make a formal response. And sometimes it's just as simple as doing a pleading. We call them motion to dismiss. But in that realm, it's frustrating because it's like somebody is pulling you onto the playing field and you don't even want to be there. You may not even have a reason to be there, but you still have to respond, because if you don't respond, there can be an automatic judgment against you in their favor. And then that judgment floats out there in the nether sphere for others to act on. So you'll have debt collectors come and they will try to get that debt. Your credit will be impacted, so on and so forth.
So that actually leads into depositions for physicians. I know I've had a couple of attendings who kind of briefly discussed it when they had to go in and do those depositions, and it's very specific. Like they want to make sure it's as narrow as possible. You're not sharing any additional information. But the odd thing is that you're also not allowed to go back into patient charts because you don't want to show any sign of like you're going in to snoop or fix anything. Like that's a big no-no. That if someone has already pulled, I guess, in discovery the chart, you don't want to go back into it afterwards. So what I've heard attendings tell me is that if you are getting deposed and you go in, and if you don't remember anything about the case, then you literally just tell them you don't remember, you don't recall, and you're choosing not to say anything because you really don't know. You don't want to add any additional information that they could use against you.
Depositions, we did a lot of depositions in family law. I actually enjoy sitting in on depositions. So for those of you who don't know, a deposition is essentially a form of discovery in which both lawyers sit in the room, and usually there's a court reporter who types up the deposition live as you go and will make a transcript of the deposition. You can also record the deposition via audio or video or both. And again, when you're thinking about billables, this adds to that final bill, because depositions aren't cheap. But essentially, if you're deposing the opposite side, they have an attorney there to represent them. But if you're deposing maybe just a witness, they may or may not have an attorney there. So, as a doctor, if you're the one getting sued, most of the time you should have an attorney there with you. And generally speaking, lawyers have a wide array of tools in their disposal to run the deposition. So, lawyers can object, but in the moment, they still need to answer the question. So, you might be asked a question, it might just be a simple yes or no question, and you might try to give an explanation, and the opposing counsel might say, they might object and then say, no, all I want you to do is answer yes or no. And then those bits of information can then get used for future trial. And at that point, it can get scrubbed where certain items that were objected to and not answered could then go before the judge, and then that information can either appear or not appear in front of a jury or in front of, the formal case. To that point, you have to be very careful about how you ask and answer questions, for the lawyer asking questions, for the defendant or the respondent answering those questions. And the rules of civil procedure give lawyers a lot of leeway to either lead the witness or not allow the witness to give a full answer that they would like to give. So, for example, if it's, did you give your patient the aspirin? That's a yes or no question. You might want to say yes because of blank, blank, and blank and justify it. But all I would say is objection. I just need you to answer yes or no. Did you do it? And then it is on your attorney's plate to then respond to that in whatever appropriate manner civil procedure allows, whether it's objecting in court or asking a follow-up question when it's their turn to ask questions. So depositions are a very strong tool. But you're right. Being able to sit back and be honest in the deposition, if you don't remember something, and saying, I do not recall that, I do not remember. But that also gets used to the point where some people who do recall it use it as essentially a lie, which can result in perjury, where you are lying under oath. And so you have to be careful with that. But I would definitely recommend, if you're in any sort of court case, deposition, if you don't recall something, it's okay to be honest and say, I don't recall it. That's completely normal. Our memories are not that good sometimes. And to that point, you might be looking back on something that happened 2, 3, 4 years ago, and you've seen hundreds, maybe even 1,000 patients since then. And that also leads to another point you made earlier about expert witnesses. So, thing that's kind of known in the law is, unless something's so far out of left field, you can have a battle of expert witnesses. So I can have an expert witness that testifies that what you did was completely unreasonable and not akin to what a physician should be doing. But then I can find another expert witness that says, no, actually, what they did was extremely reasonable, and that's exactly what they should be doing. So now it's just a matter of expert witness testimony fighting expert witness testimony. And if you're in front of a jury, then it's just who is more credible, who is more believable, who do they like more? And that gets pretty interesting.
I feel like we see that on TV shows all the time. It's something that I hear about it, but again, have not gone through, and I hope I don't ever. Expert witnesses. I know a couple of friends who do it, and there's a lot of research and information that they have to do on the back end too, to make sure that they are supporting the case in the direction that they want to. So it's interesting how all that gets used for or against.
And not anybody can just be an expert witness. It's called proving up. You have to prove up their credentials. So when they're sitting there, you have to ask them, how long have they done something? What are their credentials? What are the resume? What makes them an expert in their field? Or else you lose all credibility. And that leads me to another question. I know we've been talking about medical malpractice a lot, and witnesses and depositions and so on and so forth. But if we take a step down, I assume that medical malpractice also gets wrapped up into disciplinary action for a physician, right? So if a medical malpractice case hits, I'm assuming a board or disciplinary committee is then looking at you as a physician to determine all these other sorts of things. And there could be separate repercussions that maybe not be legal, but more so from a disciplinary board perspective. So what's your insight on that?
It's going to vary. It's a wide range of disciplinary actions that can occur, right? Depending on how bad the malpractice suit was, what occurred, how severe the outcomes were. Majority of the time, it's monetary, loss of income. You are paying higher premiums for future malpractice insurance. And then there are cases where you actually lose your license if it's severe enough, right? So that you're no longer able to practice medicine because of the suit. There are cases where maybe you've all agreed that you will no longer practice in this particular role or this particular scenario or this with this employer. So there are settlements that also will allow that as well. But the majority of the time, I see that it's either a slap on the wrist and you're just paying a little bit of money, or it's a really big deal where you lose your license. I rarely hear anything in the middle, other than cases where there's like alcohol or drug involved. Like if it was something minor and you found that the physician was under the influence, then yes, sometimes the state or the board, the medical board, will allow what we call remediation or a recovery process, so that they can, over a span of years, can potentially get their license back, but after they've lost it though. So it's still a very stressful time, no matter which end of the spectrum you deal with the disciplinary actions, whether it's minor or not. It's still very stressful to going through that process.
And I assume that medical malpractice, like a lawsuit, can be separate from disciplinary, where you don't necessarily need a medical malpractice lawsuit to be filed.
Correct. Yeah. So disciplinary actions are tiered, right? They can happen in a clinic. So if you have an office manager that is noticing, hey, maybe your interactions with patients are just not um, the best, maybe you need to work on your bedside manner, then they may report it to administration of that specific hospital system, and then they will set up courses for you. Okay, you're going to remediate by doing these courses to learn better bedside manner. Or we can escalate that up, and maybe another physician was sharing a patient with you, and they noticed, hey, he's practicing outside of the normal standard of care. He's prescribing a medication that is not standard. Then that physician can then report it to the hospital system, and that becomes a bigger thing than just remediating. Maybe now you have to go back and learn why not, or explain. You have to go through the board and sit down with a board of people and explain the reasoning behind your choice and decisions, which then can potentially limit what you're able to do moving forward, right? Maybe you've had poor outcomes doing lesion removals, for example. If you've had 4 or 5 cases all in a row in a span of 6 months, 4 to 5 different patients coming back where you removed a mole and there was a poor outcome from it, whether that was an infection, whether that was admission to the hospital because of issues, then the board may see that this is a repetitive offense. Then they may say, hey, you know what, altogether, this is probably not a procedure that you should be doing.
That's very interesting. On the legal side, we have similar instances where you can be what we call disbarred, where your bar membership is removed, your license to practice law is removed. When you're talking ethics on our side, generally speaking, if you're handling a client's money wrong, that can lead to disbarment. If you aren't communicating with your client, or you're not showing up to court for them, or you're not filing the appropriate pleadings on time, that can be disbarment. Having any sort of sexual interaction with a client, that can lead to disbarment. So yeah, you have all these different standards of, again, what would a reasonable lawyer do in this situation? And so I think any profession should have these types of standards, but I also think it gives you a little bit of paranoia on the back end. To your point, it's like, am I doing this right? Is there going to be a repercussion? And then it might stint some creativity as well, to where you're like, I think this can work. I want to try it, but I can be worried about the consequences. And I feel like as a doctor, you guys have a wide range of creativity. It's not a one size fits all solution for every patient. So, do you feel like your creativity is ever, because you're a creative person, obviously you're an artist, you have the ability to think outside the box. Do you feel like it's ever put to the side because of those standards of care that you have to adhere to?
I do think it does, but what I try to create with my patients is a relationship where they understand that I don't know everything. I mean, I try my best to read up and stay updated, but the goal is always to listen to my patients and say, hey, if this is the last resort, then maybe we have to think outside the box. Maybe we're going to utilize this medication that is typically not used for it, but we're going to try it in this scenario. So then I will cover myself by, one, being very upfront with the patient. I don't know what's going on. I don't know what this is going to do. No idea what side effects there might be, and explain to them these are the potentials. This is what could happen. You could have some relief from your pain, or this bad thing could happen, and we make a decision together, right? I don't ever go in and tell the patient this is what you have to do. No, I always lay out options. Option A, B, C, and the patient gets to choose at their comfort. I usually do that, and then I will document. So no matter what it is, I will document, okay, this is not standard of care. However, I've had this discussion with the patient. We've decided that it is within our best interest to try it for this amount of time. And if it were not to work out, then we're going to stop it right away. Patient's going to come back. We're going to discuss a different plan moving forward. So I feel like I do enough and that I've built that rapport enough that I'm hoping that that will keep me out of the realm of dealing with these legalities. But most
Yep.
patients are pretty open to that. And I think most patients have connected more with doctors who are humble and are willing to admit when they don't know what they don't know. I think that the physicians who usually get sued are the ones that are out there thinking they're God or high and mighty and treating everyone like they're lesser than. And then when they make a mistake, everyone wants to just take them down. So my goal is not to be that. I'm not on a pedestal. I'm here along with you. We're walking together and we're deciding how we can improve this path to make it easier for you to get to your end goal.
I think that's also something that happens in the legal field, at least when you're starting out, falling on your sword, admitting that you don't know everything, that you're a new attorney, or you may not have the education in a certain discipline or the knowledge in a certain discipline, but you'll work your butt off to figure it out and be the best that you can be for that individual. And I think that's something that I look for in a physician and a doctor is somebody who is transparent and communicates on that level. Because I think we've all had physicians that you go in and you speak to them, and sometimes it feels like they either don't have time for you or that they're not listening to you and you don't feel heard, or they prescribe something and then you go home and you start kind of doing your research and you start asking around like, why did I get this? And they didn't give you a reason for it. And it might be the best prescription for you, but they didn't take the time to go over your medical journey with you. And that can be something that just rubs you the wrong way.
I agree. And I think that's why in the medical field, primary care physicians or family doctors who are in the trenches, we are less likely to be sued because of the relationship that we build with our patients and the communication that we have with them. We're seeing them multiple times a year. It's not just a one-off. We've seen them at their best, at their worst. And so it gives me some comfort that I know that I'm less likely to be sued. But it only just takes one person to really derail all of that positive, uplifting mindset. But so far, I'm still good. And that's why I love being a family doctor, is because I have that time to enjoy with my patients, whether that's 20, 30 minutes, a couple times a year. But I really appreciate that.
Well, I know we're getting to the end of it, but
Mm.
the final question for you, and you don't need to name names. Have you ever been threatened by a patient to be sued for anything that you've done?
Absolutely. I think there are a lot of empty threats out there. I've been in practice for about 5 to 6 years now, and I've definitely had many threats. I have yet again not had anyone that have come to fruition. But anytime anyone is unhappy with their care or they're not getting the outcome that they're looking for, they're always going to react in a negative way. And so my goal is to try to pull them back in, and if I can, rebuild that relationship and see if we can find a different route or a different medication or a different treatment plan to help them. But if they choose not to and they choose to find a different person, then that's on them. But yes, absolutely have had threats.
It's like the old like Google or Amazon or Yelp review where the one star is always coming from the most disgruntled individual that sees the world a little differently, and you don't account for the thousands of other 5 stars that just didn't take the time to fill out the review. It's always the
Right.
one person that has to go and give you the 1 star, the half a star. But with that, everyone, that's it for this episode of the Medical Legal Brief, where medicine meets the law. If you like what you heard, share it, rate it, and give us a follow. We're on Spotify, we're on YouTube, we're on TikTok, we're on Instagram. So give us a follow on all those platforms. Let us know what you want us to tackle next time. And that's it today with Dr. Long and Lawyer Nik.
Yes, we're doctors. Yes, we're lawyers. No, this podcast is not medical or legal advice. Do not take anything we say as a reason to perform your own heart surgery, represent yourself in court, or diagnose your neighbor's rash. This is for entertainment only. Think of it like hanging out with your smartest, wittiest friends, not a substitute for an actual appointment. If you act on anything we say without talking to your own professional, that's on you. Seriously, don't do that.